Hello, everybody. Today we will talk about recent Supreme Court decision on Tiger Global. The Supreme Court of India has delivered a landmark ruling in the Tiger Global case, overturning the Delhi High Court's decision and denying treaty benefits to the Mauritius-based investor by invoking anti-abuse principles under domestic laws. The court held that tax treaty benefits cannot be granted where they result in double non taxation, signaling a decisive shift away from earlier jurisprudence. The court also denies treaty protection in case of indirect transfers. Importantly, the court ruled that the tax residency certificate is not sufficient proof of residency for claiming treaty benefits, especially after the statutory amendments introducing anti abuse tests. Consequently, the earlier position taken in Azadi Bachao Andolan, which relied heavily on TRC and pre-GAR circulars, has been deemed no longer applicable in the current legal framework. We'll talk about key takeaways from Tiger Global Supreme Court decision. Number one, mere presence of TRC will not be sufficient for availing treaty benefits in India. The non-resident will be required to demonstrate based on robust documentation that they have sufficient commercial substance. The judgment dilutes the application of the grandfathering benefit provided in Rule 10U of the income tax rules, wherein the investment made prior to 1st April 2017 have been grandfathered from applicability of GAR. As per the Honorable Supreme Court, if an arrangement which is leading to tax benefit arises after 1st April 2017 in the form of sale of shares acquired prior to 1st April 2017, GAR can still be invoked. As per the court, the fact that availing tax treaty benefits may lead to double non-taxation assumes relevance for considering an arrangement as impermissible avoidance arrangement. This observation of the court may lead to serious concern for the multinational enterprises and global funds. Many times, obtaining tax benefit is an ancillary factor for setting up operations in a country. Double non-taxation by itself does not mean that there is absence of commercial substance. The court observation on non-availability of treaty protection in the case of indirect transfers overturns the observation of Andhra Pradesh High Court in the case of Sanofi Pasteur Holdings SA. In said judgment, the High Court had observed that the indirect transfer of shares of Indian company is covered under the residuary paragraph of the India-France DTAA, worded similar to India-Mauritius, which provides taxing right only to resident state. Said finding of the court may now no longer be applicable in light of the Supreme Court observations. Resultantly, India may tax all indirect transfer cases subject to satisfaction of the domestic rules. The ruling raises questions about the criteria required to establish adequate commercial substance. It also calls for a closer examination of the safeguards that multinational investors must adopt to provide or prove the genuineness of their cross-border structures, transactions, and business arrangements in an environment of increased judicial and administrative scrutiny. The decision raises another question about the binding nature of the circulars. Before this judgment, it was a settled principle that the circulars are binding on the department unless they are withdrawn. The court noted that the circulars operate within the legal regime in which they were issued and cannot override statutory amendments. With this observation, the binding nature of circulars stands diluted and their applicability may be open interpretation even though the same are not withdrawn. The key difference between applicability of GAR and JAR lies in the burden of proof. For invoking JAR, the onus lies on the revenue to prove the abuse, whereas under GAR, onus lies on the taxpayer to disprove the presumption of tax avoidance. This shift in the burden of proof can lead to significant hurdles for the taxpayers. This is because, in absence of clear guidance, what constitutes sufficient proof will be left to the mercy of the tax officers and appellate forums. Accordingly, it is important that the taxpayers review their documentation in the case of inbound investment. So, what is the way forward for the taxpayers, that is, Tiger Global International Holdings? Given the far reaching implication of this decision, it is likely that the taxpayer may approach the Honorable Supreme Court of India once again, seeking further judicial scrutiny by way of a review petition. In a case where outcome and thereunder remains the same, the taxpayer may explore the possibility of filing a curative petition upon the fulfillment of the stipulated conditions. Thank you.